Okay, I am trying this again. I'm really sorry about the last live feed. It seems like every time I start this, the audio cuts out, so I had to restart it. I'm so sorry to all the people who are waiting. I wanted to set it up in advance, and then the audio didn't work as soon as I logged in. So I really apologize for that to everyone who was waiting. So. Thanks to everyone who's tuning in tonight for this live stream recap of what happened today in Federal Court of Appeal. Today was the second day of that 2-day hearing in the appeal of the legal challenge to Trudeau's Emergencies Act. So if you could follow along during the day, the court has their own broadcast of the proceedings. They broadcast it over Zoom. Unfortunately, you're not allowed to duplicate the stream, so I'm not allowed to have my own stream of what's happening in court, and you're not allowed to record anything that happens in court. These are all rules of the federal court that they don't make exceptions to. So if you were not able to watch it, I understand. To those who did watch it, some of you wrote to me saying that the feed was a little choppy and it was at times hard to follow along. There's nothing I can do about that. It's not my feed, it's the court's feed. And that's their own issue that there's nothing I can do about it. But I was there in person, so I took notes on everything that happened. And if you want to know what happened yesterday, there is another video on my channel recapping everything that happened yesterday. And if you want even more detail than what I'm going to give you here today, I do have a play-by-play on Twitter. So if you look me up there at C Van Gyn, you can read that. So this case that we were in court today over is, of course, it's the appeal to our legal challenge to Justin Trudeau's use of the Emergencies Act in response to the 2022 Freedom Convoy. So we won that challenge at lower court. So this was an appeal of that decision brought by the Attorney General of Canada. And in lower court, just to remind everyone of what the context here is, Justice Mosley at the lower court, at federal court, found Cabinet did not have reasonable grounds to invoke the Emergencies Act and that there was no threat to the security of Canada and there was no national emergency. These are all terms within the Emergencies Act itself. And he found that existing legal tools and authorities of different provinces had not been exhausted, which is also part of the standard for invoking the Emergencies Act. It is a tool of last resort. So after the Emergencies Act was invoked, just to remind everyone, Cabinet created regulations that prohibited gatherings that they said could, quote, reasonably lead to a breach of the peace, which is not a high standard. And people involved in those gatherings were listed as designated persons. And then Cabinet also created a regulation that required banks and financial institutions to freeze the accounts of designated persons and report their personal financial information to the RCMP. And the lower court judge, Justice Mosley, found that those regulations violated Section 2B of the Charter, the right to free expression as it related to the gatherings, and it violated Section 8 of the Charter, which is the right to be free from an unreasonable search and seizure. But he did not find that they violated Section 2C of the Charter, which is the right to freedom to peaceful assembly. So we actually had a cross appeal on the 2C issue, but we had one on every other issue. So that was the decision that was being appealed yesterday and today at the Federal Court of Appeal. And it was in front of a 3-judge panel: Chief Justice de Montigny, Justice Laskin, and Justice McTavish. And the schedule today was, yesterday was the Attorney General for Canada, as well as us, the Canadian Constitution Foundation. So today was another charity called the Canadian Civil Liberties Association, and they were represented by a lawyer named Eva Krajewska. And then there was the lawyer for 2 individuals who were directly affected by the regulations, and they were represented by a lawyer named Blair Ector. And then there were lawyers from the Attorney Generals of Alberta and Saskatchewan, and they made arguments. And then there was a reply from the Attorney General of Canada. So he kind of responded to everything that everyone said about what Justin Trudeau did. He actually said some pretty crazy, crazy things about us at the CCF. But that's going to be at the end of this summary. So there were also some arguments made by another group called Canadian Frontline Nurses. Their arguments were about mootness and standing, but because they're procedural arguments, I'm not going to summarize those arguments here today. So the Canadian Civil Liberties Association, the CCLA, EVA, they started by saying that Canada's position, Trudeau's position, has been focused on what she called multiple layers of deference. So if you watch the video from yesterday, I explain this concept of reasonableness review. That's how the court looks at the decision of cabinet to invoke, and I explain that reasonableness standard in that other video. And basically, the Attorney General yesterday was arguing for an exceptionally deferential standard beyond normal reasonableness, really. He said that the courts need to be deferential to cabinet's decision about the Emergencies Act in a double deference kind of way. Basically, there needs to be deference to cabinet about what the actual standard of invoking the Emergencies Act is, and then deference to their decision that that standard is met. And the CCLA described this as actually almost triple deference and as multiple layers of Russian dolls, of those Russian nesting dolls of deference. And that is just not what judicial review calls for. Judicial review calls on the court to ask if cabinet had justified reasons and acted within the legal and factual constraints that were upon it. And here, the legal constraints of the Emergencies Act, of the text of the Emergencies Act, they're narrow. There isn't this broad discretion that gets a huge triple amount of deference. Now, in their factum, the Attorney General argued that there are all these legal thresholds that need to be tripped in order to invoke the Emergencies Act. Like, what is a national emergency? What is a threat to the security of Canada? What does serious violence mean? And the Attorney General has said that all of these thresholds should be applied more flexibly and in a more relaxed standard that is what is actually known in law and how it's normally applied. And Eva, for the CCLA, said that that is a tell. It's a tell that the government knows those thresholds weren't met. If you need to say we need a lower standard, we need a lower, more relaxed threshold, it's because you know you didn't meet the actual threshold. So the CCLA then addressed this issue where the Attorney General has claimed that there was a fatal flaw in Justice Mosley's decisions from the lower court. They say that Mosley made his own findings of fact and law. And Eva says, he didn't do that. All he did was assess reasonableness of cabinet's decision. And the Attorney General also said that Mosley engaged in hindsight and that he had the benefit of an expanded record. And he didn't. He relied on the things that were in front of cabinet, the invocation memo, cabinet records, and information that was given to cabinet. And when you look at Mosley's reasons, you can begin with the questions of these things about whether there was a threat to the security of Canada posed by the convoy and by the blockades, and the question of if there was a national emergency. And in his judgment, Justice Mosley puts in the provisions from the Emergencies Act of what these means. And then he looked at the various arguments of the parties. So this is what reasonableness review looks like. And Eva said that Mosley identified the parts of the Section 58 explanation that speak to provincial inability. This is the last resort clause, really. The provinces need to lack capacity to act. And Mosley said, there was an inability of police. They were not working well in Ottawa. They had an inability to compel tow trucks. They didn't have this ability to cancel insurance. This is all in the Section 58 explanation. So to remind you, the Section 58 explanation is this document. It was a 13-page document that was tabled in Parliament 2 days after the emergency proclamation was issued by Cabinet, by Trudeau. And that document is supposed to provide the reasons why they invoked the act. And they had they have to lay out in the Section 58 explanation how they met the threshold of the act. And their example of that is, the police weren't working well. The province couldn't compel a tow truck. They couldn't cancel insurance. And this is supposed to speak to provincial inability. You can only act under the Emergencies Act if you can show if cabinet has reasonable grounds to believe that there's an inability of the province to deal with a situation. And so these things are supposed to show that there was a provincial inability. Mosley looked at them, he reviewed that information available to cabinet, went back to the Section 58 explanation, and he acknowledged, those things, that there's a concern that new blockades could emerge. And he said, though, that there was no evidence, that is not evidence, that those risks could not be dealt with by provinces using existing tools. So he looked at the standard, and then he looked at the facts that were available to cabinet and how cabinet explained themselves, and he checked all of that. He looked at the Section 58 explanation on the border, and he acknowledged that there was this identification of a risk of violence. And then he talked about what Ottawa police faced, but he said that the conclusion was debatable. And he said, and Eva said, it's not a reasonable conclusion that there was an incapacity here. So Mosley also looked at the 58 conclusion that there was a situation that was national in scope. Remember, when the Emergencies Act was invoked, it applied across the entire country, even though there were only blockades at certain locations and protests only in Ottawa. And Justice Mosley said that the facts just don't support the conclusion that these protests could not be dealt with using provincial authority and existing legal tools. So he checked that Section 58 conclusion against what was known to cabinet. And that is what reasonableness requires. That's what happens in a judicial review. That's what this case, Vavilov, that you might have heard referenced today many times and many times yesterday, that's what it requires. That's what reasonableness is. Now, on this other part of the threshold, remember, the threshold is a national emergency and a threat to the security of Canada, which means there's threats of serious violence. So on the question of, was there a threat to the security of Canada, Justice Mosley looked at the proclamation, which was the document issued by Trudeau, by cabinet, and it set out some of the reasons for invoking. So it does speak to the reasons. And in the proclamation, many of the issues raised were actually economic threats, which isn't part of the standard. Mosley then looked at what the factual background was. He looked at the invocation memo. The invocation memo, so I'm talking about all these documents. These are all of the things that Justice Mosley had to rely on in a reasonableness review. So he looked at the invocation memo. That's a memo that was sent from a woman named Janet Charette. She is the chief clerk of the Privy Council. She's sort of the head bureaucrat in Canada. And she sent a memo to the Prime Minister recommending invocation of the Emergencies Act. So Mosley reviewed the invocation memo, and that requires him to interpret different terms like serious violence. And the term serious violence is, in order to show that there's a threat to the security of Canada, there needs to be serious violence, which means violence to persons or property. And that understanding of what serious violence means is based on established case law. So Mosley looked at all of the facts, and he found that the threats of violence that were identified in all of these documents that were before cabinet, they were all vague. The only concrete example of a threat of violence, which is violence to persons or property, the only example was Coots. And at this point, arrests in Coots had already been made. Any other threat was speculative, and a speculative threat doesn't reach that standard of reasonable and probable grounds. So there was maybe reason for concern, but having reason for concern doesn't satisfy the test that's required under the Emergencies Act. It's just speculation. Now, on economic concerns, and I've mentioned this a couple of times, the invocation, the proclamation, and the Section 58 explanation both talk about how there was harm to Canada's economy, in particular from the blockades. And of course, there was. Those were hurting trade across our borders, which, as we are all very sensitive to right now in 2024, is a really big deal. Now, the problem is that economic harm more broadly does not meet the definition of serious violence. Causing the destruction of property could be serious violence. Blowing up a building would be serious violence, but just having damage to the economy does not meet that definition. And it's really important that Canadians know what the legal threshold to invoke the Emergencies Act is. And it needs to be based on a common understanding that can actually be articulated. It can't be in the context of lower standards. That would just grant the executive tremendous power to do things that are normally only able to be done by Parliament. And the standard is supposed to be on reasonable grounds. Now, what does reasonable grounds mean? Reasonable grounds to believe that there's a threat to the security of Canada and a national emergency. So, what does reasonable grounds mean? It means there's an objective basis for a belief based on compelling evidence. This is a standard well known in law. This is not the only time any of these judges will have heard this standard, and it certainly wouldn't have been the only time that all of the lawyers who advised the government would have heard this term. There's a different there are all kinds of different standards. There's reasonable and probable grounds, and there's standards like suspicion, a reasonable suspicion, or just suspicion. And remember, the definition of threat to security of Canada is incorporated into the Emergencies Act from the CSIS Act. And the CSIS Act uses threat to security of Canada on reasonable grounds, and it also uses threats to the security of Canada on suspicion. And that legislation uses both. When the definition was incorporated into the Emergencies Act, they could have pulled that lower standard. They could have said, oh, this will be on suspicion, not reasonable grounds. And they didn't do that. Parliament intentionally chose not to do that. They debated it. They could have created a lower standard, but they created a standard of probability, not possibility. So the whole point is that it's supposed to not be just speculative. The decision to invoke needs to be based on compelling and credible information. And in this case, Justice Mosley identified, looking at all of this information that was before the decision maker, it was just speculation to think that there were going to be threats of violence. Now, on the issue of threats to the security of Canada, the Section 58 explanation, it talked about serious violence and economic harm. And this is an important threshold. We already have a presumption at law that terms are consistent across statutes. And as I talked about in the video yesterday, this term, threat to the security of Canada, is incorporated from the CSIS Act in no fewer than 12 other statutes. So it would be unreasonable to have 12 different meanings of that term. And we know that there's a presumption that it's consistent across statutes. And here we actually have even more than that. Here, Parliament directs that the meaning is the same. It's the same in the two acts. So we aren't even relying on a presumption. Now, of course, that doesn't mean that just because CSIS said that there was no threat to the security of Canada, there was no threat of serious violence, that doesn't mean Cabinet just needs to blindly accept that they're not absolutely bound. But it's a really important factor that Cabinet had to consider. And the Section 58 explanation, which is where we're supposed to see Cabinet's thinking, it doesn't disclose that CSIS had this other assessment. We only learned about this other CSIS assessment because of the Public Order Emergency Commission. It's something, of course, Cabinet would have known and did know. We know that the CSIS director was at Cabinet meetings, and we know he informed them. But Cabinet didn't disclose that when they decided to invoke the act, and they left it, they omitted it from the Section 58 explanation. And we know now in the background that Cabinet had actually said, well, CSIS says this one thing. I guess they're not going to tell us about it, but CISA says this, let's get an alternative assessment. So we're going to have some reason to rely on to say that there was a threat to the security of Canada. Let's get something to fall back on. But then they didn't do that. They didn't go and get that alternative threat assessment. And the problem is when cabinet identifies a threat of ideological extremism and serious violence, when their own advisors and experts say there isn't one, those people who are experts in evaluating it, and then they don't have any other basis for claiming that there is this threat of ideological extremism and serious violence, they're just that's not reasonable. That's not what reasonableness requires. So that's why you see in the proclamation and in the Section 58 explanation, cabinet relying on economic harm more broadly. So if you look then at the invocation memo, this is the memo I mentioned from Janet Charette, the chief of the Privy Council office, the top civil service, that she sent to the Prime Minister. She was actually examined. She had a cross-examination at the Public Order Emergency Commission. She said that she was going to send everything to the Prime Minister. Everything would be pulled together. All the public service advice would be sort of synthesized into one thing. It would be summarized. But then when you actually go to the memo itself, it says that the provinces have already taken action. The situation remains concerning and volatile, and quoting, while there is no current information about extremism, unrest is being felt. And the invocation memo said it identified harms to things like social cohesion, national unity, and reputation. None of that is a threat of serious violence. None of it is an imminent threat from an extremist group. It's actually to the contrary of that. Is this evidence? It's talking about there being an absence of such evidence. The harms identified don't meet the threshold of serious violence, and there's no evidence of any extremism or threat of serious violence. That is what is required to invoke. There needs to be serious violence to people, like bodily harm, or property, like destroying it, not just a blockade that's causing more general harm to the economy. Now, here the Chief Justice asked a question. He said, he asked Eva from the Canadian Civil Liberties Association, did Cabinet have to wait for violence to erupt? We actually heard similar questions along these lines yesterday when we were making our submissions. So it seems like this is something in the court's mind. But I do think that we answered this well yesterday. I think the CCLA answered it well today. Eva said no. It doesn't mean that. But the thing is, the Emergencies Act is not the tool. It's not an act we use on a precautionary basis. It's not an act of last. It is an act only of last resort. And the cabinet can act. They can use the Emergencies Act. Of course, it exists for certain circumstances, but to use it, they need evidence on a reasonable and probable ground to support the action, that there's a threat to the security of Canada, which means serious violence, and that there's a national emergency. And the invocation memo doesn't show that this existed. The Public Service didn't have it. CSIS didn't have it. The National Security Intelligence Advisor, a woman named Ms. Thomas, she didn't have it. Ms. Thomas had provided an overview to Cabinet where she talked about the ongoing blockades the day before the invocation, but the threat picture regarding violent extremism remained stable and unchanged. So there was no evidence of reasonable and probable grounds that things were getting worse or were going to get worse and that action was needed immediately. So Cabinet didn't have CSIS saying there's a threat to the security of Canada. They didn't have the National Security Intelligence Advisor saying there was a threat to security of Canada. Actually, she said that things were stable and there was hope of a breakthrough in Ottawa with the RCMP and with the RCMP. So this doesn't establish any compelling evidence that things are getting worse. So the CCLA then turned to other reasons that were given in the proclamation, these reasons that I've talked to about economic harm more broadly, because now this is the only thing that they can rely on. And Eva said that economic harm doesn't rise to the level of causing serious violence to property. Now, the AG replies to this later. I will tell you about what his reply is because it's bonkers. So, the CCLA was talking about how the standard for threat to the security of Canada includes serious violence to people or property. Now, an example of that would be like a terrorist attack causing serious harm to property. That could meet the threshold, but we don't have that here. There was economic harm broadly to the economy. There was reputational harm. It was embarrassing to the government, but none of that is serious violence. That is just not what the standard is. So I think that, that was kind of it for the CCLA. They said that the threshold to invoke the Emergencies Act wasn't met. And then the CCLA brought up their second lawyer, a lawyer named Brendan, and he was going to be talking about the charter issues. So you'll remember there are three charter issues. There's Section 2B of the charter, which is free expression. There's Section 2C of the charter, which was freedom of assembly. We lost on that at the lower court. Justice Mosley found there was no breach. And then there's Section 8 of the charter, which is reasonable search. Oh, I guess there's four charter issues because the last charter issue is Section 1, which is the limitations clause. So all of these rights that we have under the charter can be reasonably limited. There can be reasonable limits if they're demonstrably justified in a free and democratic society. So there's a test for that. Basically, the test, the limit needs to be proportionate, it needs to be minimally impairing, and it needs to have a rational connection to a valid public purpose. So a lot of this will come down to that the one minimal impairment. So the CCLA said that the CCF, had made submissions on all of this yesterday, and our lawyer, Janani Shanmuganathan, did a really amazing job on that. But he said he wanted to drill down a little bit on some of them. So he said, Brendan from the CCLA said that he agreed with the Attorney General that the scope of expressive activity is broad, and the court shouldn't get into if they agree or disagree with the message being conveyed. I mean, that's pretty basic stuff. He said that 2B, expression, and 2C, assembly, have the same internal limits, which is violence. But what divides us from the Attorney General is what actually constitutes violence, what amounts to violence. And the Attorney General's position is essentially that disruption and interference is violence. We say that, the CCLA says physical violence and threats of it is the actual limit. Like actual violence is violence, not just disruption. So the Attorney General said some activities can be purely physical in a way that doesn't convey meaning, but the idea that protests, and these protests in particular, that they were purely physical is really untenable, especially when you look at that Section 58 explanation from the government. It makes it clear that they knew that these were expressive political protests. Demonstrating is a well-established expressive activity, is protected under our charter. The right to protest government action lies at the core of constitutionally protected expression. Now, the Attorney General claimed that the quote domination of physical space is not protected expression. But every single protest and most things, anything that's expressive, involves using space. If I'm in space, you can't be in that space because I'm in the space. Doing anything expressive necessarily excludes another person from that space. But to convey, to kind of drive home their point, the Attorney General used these scary words like domination. And there just isn't a meaningful constitutional distinction between occupying and taking up space and dominating it, just because dominating sounds scarier. So none of those things, taking up space doesn't take you out of an activity being protected under our Constitution. So it's also really important to look at the text of those orders, the orders that prohibited certain gatherings. And a number of those regulations don't even talk about blockades. They just talk about disruption. And some of the regulations just talk about interference with infrastructure and, quote, serious disruption of the movement of persons. So you don't even see a reference to a blockade, which would be more likely to fall under that category of expression that's not protected. Now, on Section 8, the charter arguments on Section 8 relate to the right to be free from an unreasonable search and seizure. So the idea that the bank accounts were frozen was a seizure, and that information that was sent from those accounts to the RCMP by the banks, that was a search. So we focused a lot on search yesterday. So Brendan from the CCLA spent more time on seizure. So he said, to be a seizure, there needs to be a taking with a super added impact on privacy rights that occurs in the context of a administrative or criminal investigation. Now, the Attorney General has said these freezing orders were not about an investigation. It was just about ending the protest. But this fails to grapple with the relationship between the freezing order and the protest ban. The freezing order was to further the other regulations. That's why the entry point of the freezing regulation is a designated person, a person who's engaged in one of those protests that they banned. It required the freezing order required coordination with the police. Banks had to send private, confidential financial information to the police, and the information given to police could be used to further investigations. And you can into those crimes of engaging in these unlawful gatherings, which remember came with a penalty of up to 5 years in jail. So you can look through the fact that you can just look at the fact that there were two instruments that were fundamentally related as part of one scheme, and you can just see by looking at it that it's criminal in nature. Now, the Attorney General has talked that there are so the standard under the financial orders was a standard called reason to believe, which is lower than a normal criminal standard. And the Attorney General has said, look, we chose reason to believe, and that's totally fine because there are other statutes with this reason to believe standard. And the government specifically pointed to some sanctions legislation. And they said, look, this sanctions legislation uses this lesser standard to interfere with people's finances. So this standard is okay. But the CCLA made 3 points. First, those sanctions laws actually have never been judicially or constitutionally scrutinized. So we should not take anything from their mere existence. Their mere existence is not a constitutional endorsement of that standard. In fact, that standard could very well be unconstitutional. Second, the sanctions legislation, unlike the emergencies order freezing orders unlike the Emergencies Act freezing orders, the sanctions laws actually have a mechanism to review the designation of those people. If you had your account frozen under the Emergencies Act order, you had literally no recourse. The recourse the government said you had was to call your bank to complain. Like, that's not a procedure. That's not recourse. There's no review mechanism. And the sanctions legislation does have a review mechanism. Now, third, the CCLA said the sanctions legislation is not the right comparator here because they relate to civil forfeiture and extraterritorial conduct. There are only criminal offenses for third parties dealing with sanctioned per people. The sanctions legislation don't end in criminal prosecutions the way the emergencies orders did. So all of this, the exposure to criminal consequences with these Emergencies Act orders, combined with the freezing, that means that the freezing orders needed a criminal law standard. And to the extent that there isn't one, because there isn't, it's a breach of Section 8. Then the CCLA turned to that last charter issue of whether the breaches of all of this, of 2B, 2C, and 8, if they could be justified under Section 1 of the charter. And Brendan from the CCLA said they can't. It would have been easy, though, for them to tailor these measures to make them less impairing on the rights of people protesting. The government could have restricted could have tailored the gathering limits to prohibit violence or blockades. They could have created an objective standard. They could have specified geographically where they applied instead of making it apply to the whole country. And none of that's a hindsight analysis. It's all an analysis rooted in well known case law and drawn from the basic tenets of our constitutional architecture. And to the extent that they depart from all of that, they are not justified limits. So that concluded the CCLA's submissions. Next was a lawyer named Blair Ector. He's a lawyer from Alberta, and he was representing two individuals who had attended the protests and had their bank accounts frozen. And their names were Mr. Cornell and Mr. Gersey. And Blair made a number of submissions as well on Section 8, the searches and seizures. But since I've talked about the Section 8 stuff a lot already, and it's kind of this all the same, I'm not going to repeat it. Instead, what I want to focus on from Mr. Ector's submissions is those stories of his two clients, Mr. Cornell and Mr. Gersey, because I think it will really give you a clear image of actually what these measures did and how they hurt ordinary Canadians who were expressing their political views, as is their constitutionally protected right. Now, Blair explained that the Attorney General yesterday had said something completely incorrect. He had said that the Attorney General had said, as soon as you left the protest, your account would be unfrozen. And that's not what happened to Blair's clients. His clients' accounts were not unfrozen right after leaving the protest. Their accounts were not unfrozen until they returned home, which was, in the case of one of his clients, all the way in New Brunswick. So it took him a really long time to get his account unfrozen. So Blair described, first he described Mr. Cornell. Mr. Cornell is a veteran. He had been awarded various medals for his service, including a Medal of Bravery. He lived in New Brunswick, and he went to Ottawa twice for these protests. First, he went with his wife, then he went again alone. And his involvement in the protests was entirely peaceful and dedicated to liaising between the police and the protesters. And he wore his medals while he did this. And I think overall had a positive experience in doing this. Now, his banking, after the invocation of the Emergencies Act and the implementation of these freezing orders, Mr. Cornell's banking services were frozen without any notice. All of his instruments, all his financial instruments were frozen. And he was 1,000 kilometers from home, and he only had a small amount of cash in home or in his wallet. So he had to rely on that small amount of cash and the generosity of strangers. Because his account was frozen, his accounts were frozen, he missed bill payments, and he had to go all the way back from Ottawa to New Brunswick to his wife without any money in the dead of winter. And his accounts were not available until well after he was back in New Brunswick. So put yourself in Mr. Cornell's shoes. He had served his country with bravery, with commendation from his country. He retired to pursue public service. He then exercised the constitutional rights that he had dedicated his life to, and he was, as a result, targeted with these sanctions. He was betrayed by his country that he had put his life at risk for. He is not a terrorist. He's not violent. He's not an enemy of the state. But Blair explained that his government treated him like one, and that is an injustice, and it needs to be condemned. Now, Blair's other client was a man named Mr. Gersey, and Mr. Gersey had had a career in law enforcement and then retired. He went to the protests in late January in Ottawa and remained for 3 weeks. And his participation in the protest was minimal and it was peaceful. And on February 19th, his bank accounts were frozen. But unlike Mr. Cornell, he had no cash with him. And it was as a result of having no cash, he had no money to get home. So he had to rely on the generosity of strangers, not just to return home, but to actually shelter himself in the interim. And freezing his finances actually, ironically, made it impossible for him to get home. And his accounts were not unfrozen until well after he left Ottawa. And what Blair has asked for is for justice to be upheld so that people never experience something like this again. Neither Mr. Gersey nor Mr. Cornell are either far right, they're not extremists, they're not whatever label the government wants to put on them. And what happened was these orders were created. They acted, the orders themselves were judge, jury, and executioner. There was no way for them to appeal the freezing order, even after they left. There was no prior authorization, like a warrant that required anything to freeze their account. There was no neutral third party to review it. That on its face is unreasonable, and it's contrary to the leading case law on searches, a case called Hunter and Southam. And, as I mentioned yesterday, the Attorney General had said, if your account was frozen, you did have recourse. You could call your bank and complain. I mean, that is insane. And Blair, the lawyer for these two men, he said, obviously, if that had fixed the problem, they wouldn't be here in court today, because that was quite obviously the first thing that they did. The attorney general saying that the appeal mechanism is to call your bank, uh, that is so problematic. That is not a fair procedure. It's not even a procedure. So I thought that these were really good stories, and I do wish well to Mr. Gersey and Mr. Cornell, and I hope that they're doing better. And I'm sorry for what happened to them. And I'm grateful for Blair coming and arguing their their case so well and telling their story in such a compelling way. So next up was the Attorney General of Alberta. So the Attorneys General of Alberta and Saskatchewan both were involved in this case. I think they were interveners. Neither of those provinces wanted the Emergencies Act to apply to their jurisdiction. So they both that both of those provinces, the leadership had objected. So the lawyer for Alberta said that the principles of federalism are really important context for what happened with the Emergencies Act. The jurisdiction of provinces needs to be respected as equal. We're in a federalist country. The federal government, the Ottawa government in Ottawa, doesn't just run the whole show. The provinces are equal parts of this federation. The interpretation of the Emergencies Act needs to be done, Alberta said, in light of the narrow objective of the Emergencies Act, which is to resolve a true emergency. And it should not be unduly broadened, because it's actually the constraints in the Emergencies Act that make it constitutional. So Alberta's position is in line with the principles of statutory interpretation, the modern principles of statutory interpretation, that the interpretation of a statute needs to be tied to its objects. And modern principles do not mean that legislation with a narrow object and stringent tests can be read in a different way. And a big part of Alberta's submissions was actually on the province's capacity. Remember, to use the Emergencies Act, the federal government needs to show or to have reasonable grounds to believe that that provincial capacity has been exceeded. So there was a lot of time spent on that, and a lot of time spent on the consultation with the provinces. So that's another requirement. To use the Emergencies Act, the feds need to actually consult with the provinces. Now, on the capacity of the province, on the ability of Alberta to deal with the situation, Alberta said there are actual factual inputs that showed that capacity in Alberta was not exceeded. They said the most serious situation was in Coutts, where the cache of weapons was found and criminal charges were laid. And Alberta said that the clear fact that the protests at Coutts had been reduced to 40 vehicles from, I think it was 200 plus, before the Emergencies Act had been invoked. Before it was invoked, they already reduced it down to 40. And arrests had been made. The weapons had been seized. And it shows that it wasn't necessary. This was all known to Cabinet before the Emergencies Act was invoked. And Premier Kenney sent a letter to Justin Trudeau, reiterating all of this. And this had been said during the consultation, reiterating that the Emergencies Act was not required to address Coutts, and it detailed all of the enforcement action that had been taken at Coutts, and it explained the source of the authority that had dealt with this Coutts situation. So here, the Chief Justice asked a question. He said, "Doesn't the act doesn't require Alberta to consent just to be consulted?" And Alberta said yes. But the point is, Alberta's feedback and the input about their own capacity was just not considered by cabinet. Premier Kenney said that Coutts was being dealt with using existing law and provincial authority. The issues in Alberta were resolved. How was cabinet using that information to justify the Emergencies Act when Alberta was saying the test isn't met? We have capacity and authority, and it was known to cabinet that the Coutts enforcement action had been completed using existing tools. Alberta also talked about how the Attorney General for Canada is now using an earlier request that Alberta had made for help. They're using that against them. So I haven't talked about this before. It's sort of like a more minor issue, but it's interesting. So on February 5th, Alberta made a request of the feds to borrow some equipment to address the situation in Coutts. I think it was some large special towing equipment to remove big rigs. And Alberta asked if they could borrow this equipment. And the Attorney General is now saying, see, look, their capacity was exceeded because they wanted to borrow this equipment. And that's how we know the threshold to invoke the Emergencies Act was met. But, a letter asking to borrow something on February 5th and a conclusion that there was a lack of capacity on February 14th, nearly 10 days or 9 days later, those are not the same things. The letter asking to borrow equipment for help, that's an established procedure. It's an existing legal tool. It's an existing mechanism for cooperation. It's included as part of Alberta's capacity. Yet Canada, the Trudeau government, now wants to rely on Alberta's attempt to use that mechanism, an existing legal tool. They want to use it against them. The Alberta Attorney General then talked about the consultation between the provinces and the federal government. Remember, this is a required part of the use of the Emergencies Act. The feds have to consult, although technically the provinces don't have to consent. They need to be consulted. And 7 out of the 10 premiers said that they didn't need the Emergencies Act declaration in their province. And Alberta was one of them. Alberta said their capacity wasn't exceeded and they had enough to deal with everything. But when you look at the invocation memo that was sent from Clerk Charette to Trudeau, it doesn't talk about any of that. And indeed, the memo might have mischaracterized the support of those other 3 premiers. There were 3 premiers who did support invocation: Ontario, Newfoundland, which doesn't make sense because there weren't any protests there, and they were nowhere near the protests, and BC. But characterizing BC as fully supportive is inaccurate because BC also expressed concerns about intrusion into their jurisdiction and concern that the Emergencies Act use should be geographically focused. So characterizing that as supportive is not entirely accurate. And then, of course, there were 7 provinces who were opposed. And in the invocation memo, all of these provincial inputs were really just glossed over. The memo just kind of vaguely recaps what happened at the consultation with no specifics about how capacity and how much capacity or how much authority there was. It just said, it just kind of like very briefly summarized it without being specific that these provinces don't actually want this. 70% of them didn't want it. And looking at specific elements of capacity and authority is part of what should be required. And the decision maker, cabinet, didn't grapple with any of that. And they're required to. They're required to grapple with that. They're required to consider these inputs, even if they're not bound by them. It's really compelling information that none of these provinces, 70% of them didn't want it. And BC said that it should be geographically limited. And the Section 58 explanation didn't deal with the provincial comments either. That explanation said it said that they were in contact with the provinces and then to look at another different report. And the Section 58 explanation summarized measures in Ontario, New Brunswick, Nova Scotia, and didn't engage further with any of the input from the provinces. And it was incumbent on Cabinet to consider this. The Prime Minister also wrote a letter to the premiers on February 15th explaining why he invoked the Emergencies Act. And that letter from the Prime Minister explained what Canada was proposing doing. It said in order to address premiers' feedback, it just said that their feedback was taken into account. There was a real need to actually meaningfully grapple with what the provinces had said about their authority and capacity. It's part of the test to use the Emergencies Act. It's very important feedback in considering whether that threshold is met. And we can see there's no grappling with it in the invocation memo, no grappling with it in Section 58 explanation, no grappling with it in the letter from the Prime Minister. And in fact, there's not even an accurate description of what the provinces had told the federal government. And the importance of grappling with what the provinces have said, what their inputs about their authority and capacity are, it's really, really important when you consider it and you balance it against how far the Emergencies Act intrudes into provincial jurisdiction. Now, next up was Saskatchewan. They, as I said, had also opposed invocation of the Emergencies Act in their province. And they started by attacking the Attorney General of Canada. They characterized the Attorney General of Canada's argument as saying that the Constitution doesn't require the Emergencies Act to be interpreted with restraint and hesitation. That's what the Attorney General said, and the Attorney General of Canada said, and that the Emergencies Act allows the federal government to encroach on provincial jurisdiction, and that is not unremarkable. And Saskatchewan said this is astonishing, and that they could not disagree more. Saskatchewan rightly jealously guards their jurisdiction. So to say things and this, just as an aside, this particular federal government has a real problem with intruding into provincial jurisdiction, in particular in Western provinces. So I understand the anger from the Saskatchewan Attorney General here. He said that it shows the Cabinet got off on the wrong foot when invoking the Emergencies Act, and these statements all fly in the face of Privy Council and Supreme Court case law. The discretion to invoke the Emergencies Act is not broad. It is, in fact, incredibly legally and factually constrained. It's a high threshold to invoke, and it should be. And if the thresholds aren't met, there's no legal authority to invoke. And if the facts don't support the preconditions, saying we have a lot of discretion doesn't get you around that fact. It was unreasonable. Saskatchewan said it was unreasonable to see this as a national emergency because Windsor was resolved. Coots was resolved with existing tools. There was a meeting with the premiers where 7 out of 10 said no Emergencies Act needed. Even if Cabinet thought that there was a risk of future disruptions, the only reasonable conclusion should be that provinces can deal with it using existing laws, as had been happening up until that point. All that was left, Saskatchewan said, was Ottawa, and Ottawa is a local concern. It's not a national emergency. And I do think that there's something to that. I think that people in Ottawa think that Ottawa is the entire country. And I think if I was in Saskatchewan, I would be quite resentful of that perspective. So that's an aside. That's sort of what my thought is. Now, Saskatchewan said it was unreasonable to conclude that the protests exceeded provincial authority and capacity to deal with. That Section 58 explanation talked about the provinces not being able to, quote, effectively deal with protests, but effectiveness is not the test. The test is capacity and authority. And the feds can't intervene just because they think the provinces aren't doing a good enough job. That's what they want to intervene on about everything, by the way. Think of the carbon tax. That's exactly what that was about, too. They just thought the provinces aren't doing a good enough job. another aside from me. So this interpretation, Saskatchewan said, is consistent with the principles of federalism and consistent with how federalism gives autonomy to the provinces. Saskatchewan said that the Emergencies Act is the legislation itself is not aimed to deal with what he said were yahoos honking horns. It's aimed at things more serious than that. And he said, look, the Ottawa protests were not peaceful. It was beyond peaceful. But that's still not the threshold to invoke the Emergencies Act. There must be serious violence in the context of a true national emergency, and it was unreasonable to interpret economic damage as serious violence. He said there might be a gap in the legislation. Maybe economic harm should be part of the Emergencies Act, but that's a gap. If that's a gap, it's a gap for Parliament to fill. It can't be filled by this court accepting a contorted definition of violence. Now, the day ended with the Attorney General replying to everyone. Everyone's kind of been coming at the AG here. And so the AG gets to come back. They get the last word on this. And they really came after us at the CCF in particular. They really objected to our argument that the bank account freezing orders were criminal law. They said the regulations made some types of participating in protest offenses, no question. And the economic order applied to people offending that regulation. But the AG said there's no equivalent offense provision in the economic order. What the economic order does is impose duties on financial institutions and immunizes them from civil liability. He said there's no offense for having an account frozen. Having your account frozen is not a criminal offense. So there's no reason to apply criminal law standards. I mean, this is just wrong. But the reason they have to say this is they don't have a choice, because they have to say this isn't criminal law, even though it obviously is, because if it's criminal law, the search is so obviously inadequate under the standards of criminal law. So they have no choice but to argue that it's not criminal law, even though that argument is an absurdity. Now, on Coots, the Attorney General responded saying, we've all argued that Coots and the other border blockades were resolved on February 14th, but he said it's not up to us to sit here now in 2024 and say this. He said that was inconsistent with Cabinet's view. Cabinet didn't think it was concluded. And he said, just look at the Section 58 explanation. It's all in, it's saying RCMP seized weapons and ammo, and there are elements within the protest with an intention to engage in violence. There were at the time those elements. So he said, look at the tense that's being used here. It says there are these elements right now. So the view of Cabinet was that Coots was far from resolved. It indicates that the situation Cabinet believes is ongoing. And even situations that were resolved or semi-resolved, like some of the borders, he said that the Section 58 explanation described an ongoing kind of push-pull with protesters, that they could come back at any moment. Then the Attorney General really kind of went off on us, specifically the Canadian Constitution Foundation. He was really not happy with the argument that we had made. He said Cabinet, when they invoked the Emergencies Act, was not required to anticipate every argument that we at the CCF would sit here 2 years later and bring. He said they're not required to anticipate every ornate argument come up by the CCF. I mean, I love that he called it ornate, because we are literally reading the words of the statute. So if you think the text of the law is ornate, it's actually ornate that they've given it their own bizarre new interpretation, where a law with the same words has all of these different meanings and all these different statutes. Like, that is ornate. We're just like reading the law. And he also said that the CCF's theory is that the whole point of the Emergencies Act was to prevent something like the panicked overreach we saw in the FLQ crisis 55 years ago. He said, according to the CCF, the Emergencies Act must be interpreted as impossible to invoke unless the government is being violently overthrown, and provinces and police are unable to use resources, and they need to comb through every part of the criminal code for unusual provisions to use and ask for help. And this is like, obviously, we were even asked a question about this by the Chief Justice. So I don't think it's a very effective thing to try to answer the question that we were already asked by saying we say it's impossible to use. We literally say it should not be impossible to use, but it should be used according to the standard in the text of the Emergencies Act. So he then said it was like a fascinating theory we had presented very spiritedly, and would make a compelling paper or lecture, which is kind of um, a insult by way of compliment for the lawyer representing us, who is a very well renowned scholar and academic, as well as constitutional barrister. So he's trying to say like, oh, these are just these fancy ideas. But the reason he's making such a personal attack is because he's afraid of our argument and has failed to grapple with it, and failed to grapple with the history of the legislation. And he's mischaracterizing our argument by building this straw man so he can tear it down. And that is just what you do when you are outgunned, which I have to say, in our lawyer's amazing in this case. And he really did outgun the attorney general here. And that's why he spent so much time going after us specifically with these like really personal attacks. But then he went too far. I'll explain what happened. So he said, the attorney general said, we can all sit here now and imagine what could have been done and what should have been done. And even incredibly, the Canadian Constitution Foundation, one of their ideas of a better solution was to call in the army. We actually did not say that. So I don't know why he said that we said that. And the Chief Justice actually interjected. He was like, wait, what? When did they say that the government should have called in the army? And our lawyer, Sujit, jumped up and said, we never said that. We never said that. We never said call in the army. So then the attorney general had to take that back and correct himself, which then undermines his credibility and shows that this is all a mischaracterization of us. Right as he's wrapping up with these reply submissions, like that is not good. If I was listening as a neutral third party, I'd be wondering, what else of the argument is the attorney general wrong about? What else is he mischaracterizing? And this was at the very, very end of the day. So that was it. That was the day. Now we wait with Justice Mosley to get a decision from the federal court. I think it took 8 or 10 months. Typically, we expect 6 months. But this case is especially complex. And I believe, like Justice Mosley's decision, because it was a federal court decision, I believe it. So his needed to be translated. I think this will also need to be translated. So we might need a little extra time. Now, there is a big question a lot of people have asked, which is what if there is an election? And this is a good question. We've been asked this many times. I think if we win this case and there's a new government and the new government is conservative, they would probably not appeal this case. So then it wouldn't go to the Supreme Court. The Conservatives have been very consistent that Trudeau was wrong to use the Emergencies Act. So I think if they were to form the next government, it would be, and if we won, it would be up to them to decide, like, are we going to appeal this case? I think if they were to win government and we won the case, that would probably be the end of it. But if we lose, then of course we would appeal. But let's not imagine a scenario where we lose, like send only good thoughts right now. Now, if you do want to learn more about our case, the factum, where you can read our whole argument, that's on our website. If you go to the ccf.ca just the ccf.ca and put in Emergencies Act in the search, you'll be able to find it. I also have a playlist here on YouTube that's dedicated to this case. So if you want to watch more videos about this specific case, you can do that. And of course, if you want to help financially with the costs associated with this case, you can make a tax-deductible charitable donation at the ccf.ca/donate. So I can't believe how many people are interested in this, and I really appreciate all the interest. There were a few people who came to court in person, so thank you to the people who came. It was really nice to meet you, and wish us luck. This was a really big deal. I was so pleased to be a part of this, and it's sort of been a real highlight of my legal career to be involved in this case. And none of it would have been possible without all the people who donate to keep our little organization alive. So thank you and have a great night.